Okay, next up, we have Adele Nicholas, who is joining us from Illinois. Adele is a civil rights attorney who focuses on helping clients who are victims of wrongdoing by corporations and government entities, including people like incarcerated folks and the homeless. A 2008 graduate of the John Marshall Law School, Ms. Nicholas is licensed with the bar in the state of Illinois and admitted to practice in several federal court districts in Illinois and Wisconsin, the Seventh Circuit U.S. Court of Appeals, and the U.S. Supreme Court. She authored a chapter of the 2017 edition of the Civil Rights, Litigation, and Attorney Fees Annual Handbook. She's a member of the Chicago chapter of the National Police Accountability Project, and she serves as a volunteer attorney for First Defense Legal Aid, a Chicago-based organization that protects the right of people who are in the custody of the Chicago Police Department. Her work and activism were recently profiled in the Chicago Reader. Now, Adele notes that she, in addition to her legal prowess, she is also a musician who composes and performs with a couple of Chicago bands. So maybe if we ask her all the right questions, she'll perform for us at the end. But for now, she's going to tell us about a couple of her legal efforts in Illinois on behalf of people who are trying to really gain their freedom after completing their sentences. So Adele, it's great to have you with us today. After a short transition here, the forum will be yours.
Thanks for having me. My name's Adele Nicholas. Thank you for that nice introduction. I'm an attorney based in Chicago. I've been doing work on behalf of people who are required to register for about the past 6 years, along with my colleague, Mark Weinberg. Today, I'd like to give an update about litigation that Mark and I have been working on for approximately the past 5 years on behalf of people imprisoned in the Illinois Department of Corrections seeking release on mandatory supervised release. Back in August 2016, Mark and I received a letter from someone named Alfred Akama. And he was a man who was imprisoned in the Illinois Department of Corrections on a 5-year sentence that was to be followed by a term of supervised release that was indeterminate, 3 years to natural life. And in his letter, he explained to us the situation that he and many other people imprisoned in the Illinois Department of Corrections faced. The IDOC will not release someone from prison until they have an approved host site at which to live while they're on supervised release. He personally had no money to pay for housing of his own. There were no halfway houses in the entire state that would accept someone with a sex offense conviction. And because he had an indeterminate period of mandatory supervised release, he could end up spending the rest of his life in prison, even though he'd only been sentenced to serve 5 years. And in his letter, this is what he wrote. All the time the inmate spends in IDOC waiting for a host site is dead time. Thus, if a person cannot find a host site that IDOC is able and willing to approve, very difficult, they will serve the entirety of their MSR term behind prison walls. A 3 to life inmate will spend life in IDOC on MSR. And when we first read this letter, we thought this could not be true. Someone who was sentenced to 5 years in prison couldn't possibly serve the rest of his life in prison just because he couldn't afford a home. But as we started to research the situation, we soon realized that was exactly what was happening. And Mr. Akama wasn't the only person in that situation. There were approximately 250 to 300 people who were in exactly the same situation as Alfred. They were at risk of serving a life sentence that they were never sentenced to by a court. I think that the way this situation came about is kind of a microcosm of how all of our sex offense laws and policies, not just in Illinois, but around the country, have gotten so bad. And that is, nobody passed a law that said, let's keep people in prison forever if they're poor. Let's keep people in prison forever if they can't afford a place to live. That's not what happened. What the Illinois legislature did was they passed a series of laws, each of which made it a little bit more difficult to find a compliant place to live. And in isolation, Any one of these laws sounds like it might be reasonable, especially to constituents who want their legislators to be tough on crime, focused on community safety, and cautious about where people who've been convicted of sex offenses are allowed to live. But over time, as these laws get layered one on top of another, we ended up in the situation we're in now, where we have a completely Byzantine system that's impossible to navigate, creating all of these unintended consequences that run completely counter to public safety and are wasting the state of Illinois millions of dollars a year. So I want to explain a little bit about all of the overlapping laws that led to the situation we're in Illinois. Okay, first, any person sentenced to serve a term of imprisonment in the Illinois Department of Corrections receives a separate sentence of mandatory supervised release. Mandatory supervised release is similar to what we think of as parole. It's a post-incarceration term of supervision that's supposed to be served in the community. The difference between MSR and traditional parole is that MSR is a separate sentence of community supervision that only starts after the person is released from prison. It's not early release on an incomplete prison sentence. For people convicted of sex offenses in Illinois, the amount of MSR time they have to serve is set by statute. And for many offenses, the required term of supervised release is an indeterminate amount of supervision called 3 to life. So it can be as short as 3 years, it can be as long as the rest of the person's life, but the sentencing judge sets it as an indeterminate term to be determined after the person is released. The next situation that folks with this 3 to life sentence face is that they cannot be released from the Illinois Department of Corrections unless and until they identify an approved host site at which to live while on MSR. And the host site requirements imposed by statute and IDOC policy are so onerous and so difficult to comply with that at any time, there are approximately 1,200 to 1,300 people in the Illinois Department of Corrections on technical violations of their MSR, meaning they didn't do something wrong. It's simply that they cannot meet this host site requirement. So for people with a determinate amount of MSR, for example, 2 years of supervision to serve, they oftentimes simply are forced to, quote unquote, max out that time, meaning they remain in IDOC until they've just run out the clock on their supervision, and then they're released without supervision at all. Not because they wanted to stay in IDOC that extra time, but simply because if you can't find a place to live, you have no choice but to stay in prison. For people with 3 to life, that is not an option because under Illinois law, people with this 3 to life sentence of supervision, the law provides that the term of extended mandatory supervised release shall toll during any period of incarceration. And what that means is that someone with 3 to life, their time on supervision never starts to run until they actually get out of the IDOC. So someone who has served his entire prison sentence can remain in prison indefinitely if he's unable to identify a host site. Why is it so hard to identify a host site? Well, there are many levels of restrictions that make it difficult. First thing is that the Illinois Department of Corrections has the sole authority to decide whether a host site is compliant, and a person cannot be approved for release from IDOC until they have the approval of the parole department to say this is an approved place to live. Where do they get these restrictions from? There are 3 sources. The first is Illinois law. Second is IDOC policies that oftentimes go beyond Illinois law. And then the third is the discretion of the parole agent to approve or deny host sites. Let's look first at the law. So Illinois law imposes a statewide restriction of 500 feet from schools, playgrounds, and daycares for people who've been convicted of offenses involving a minor victim. The Illinois parole statute also provides that individuals convicted of sex offenses may not live, quote, near beaches, movie theaters, parks, swimming pools, or any other places where minor children congregate while they're on supervised release. Another section of the parole statute provides that only one registrant who is on parole may live at any address. And that applies to the same house. It also applies to an apartment building and an apartment complex. So even if someone can identify housing that complies with the 500-foot restrictions, which are already difficult to comply with, only one registrant can live at that address. And if another registrant happens to move into the same building, even if it's a large apartment complex with dozens or hundreds of units, that becomes an illegal place for a parolee to live. And then finally, there is an electronic home detention requirement or electronic home monitoring requirement for many people released on supervised release for sex offense convictions. And that means that homelessness is not permitted because in order to be on electronic home monitoring, you must have a home at which to plug in this device that will monitor whether you are within a certain proximity of that monitor. Adding to those restrictions, which already make it hard to find a compliant place, are IDOC policies that were layered on top of the restrictions imposed by Illinois law. These things included an interpretation of the one person per address rule to apply to trailer parks, apartment buildings that are owned by the same landlord if they are next door to one another. The 500-foot rules by statute only apply to people convicted of offenses against minors. IDOC decides to apply them to everyone convicted of any sex offense, even if the victim of the offense was an adult. IDOC has decided that people on supervision for any sex offense, whether it was related to the use of a computer or not, may not live at any host site that has the internet, Wi-Fi, or even internet accessible devices. And then the IDOC has also decided that people on MSR for sex offenses cannot live at any address where children reside, including if they're the parolee's own children. So you can see how we are quickly closing off options to people. Then making the situation even worse is the discretion of parole agents to deny approval for a host site for nearly any reason they see fit. For example, if they observe children in a nearby house, not the house that the parolee seeks to live in, they can deny a host site for that reason. If there is a dog or another pet at the residence, they can deny approval. If there are children's items at the host site, toys, books, clothes, even if there are no children, they can deny the host site for that reason. If there are photos of a minor on the premises, if there is a safe, binoculars, a gaming system, really the sky's the limit. And parole agents are given tremendous discretion to deny approval for host sites for almost any reason they see fit. So you quickly see how it becomes impossible for people to identify a host site. Compounding the problem is the fact that there is no free transitional housing that can accept someone with a sex offense conviction in the entire state of Illinois. Because of restrictions imposed by Illinois law, halfway house providers stopped accepting people with sex offense convictions because the licensing requirements became so onerous that many of them just simply could not afford to meet them. IDOC does not let parolees live at shelters. IDOC does not let people with sex offense convictions go into work release programs. Under Illinois law, anyone with a sex offense conviction and a sex offense registry requirement is not allowed to live in subsidized housing. And so this has created a situation where someone who is poor and needs a place to live while they get on their feet and find work has no options under Illinois law. So we filed a class action lawsuit in which we asked for an injunction on behalf of everyone who is unable to get out of the IDOC due to their inability to find or afford housing. And in the course of this lawsuit, we took the deposition of the deputy chief of parole, the person who's in charge of the IDOC's parole department, and we asked this question. Is it possible for a sex offender with an indeterminate MSR term who A, does not have money to pay for his own housing, and B, does not have family or friends on the outside who can pay for his housing, to ever get out of the Illinois Department of Corrections? Answer, never say never, but using those criteria, no. So our lawsuit is named after a man named Paul Murphy, and he was kind of the poster child for how badly these laws are malfunctioning. Paul was convicted in 2012 of possession of child pornography, and his initial sentence was probation. As I'm sure most of the people on this call know, a conviction like that greatly destabilizes a person's life, and Mr. Murphy unfortunately lost his job and his housing. And after he spent 18 months on probation, he was revoked. And the reason he was revoked was that he was homeless, and he was determined to have been sleeping in the doorway of a church that was too close to a park. Because his probation was revoked, Mr. Murphy was sentenced to prison with a 3 to life term of mandatory supervised release. He became eligible for release in March 2014, meaning he'd completed his sentence of imprisonment and was ready to be released on MSR. But because he had no host site, he was still in prison when we filed this lawsuit several years later. In the case, we asserted several constitutional claims, and we didn't attack one particular law. We said this whole system of laws is violating people's constitutional rights. Our first claim was under the Eighth Amendment. We said this system is criminalizing homelessness. It is essentially punishing people for being poor. And this is a violation of the cruel and unusual punishment clause of the Eighth Amendment. Relatedly, we asserted a claim under the 14th Amendment, Equal Protection Clause, saying that this system of laws treats people differently based solely on their poverty. And then we asserted due process claims. Under the substantive component of the due process clause, we said that this was simply not a properly tailored way of advancing the state's interests in public safety. Taking away people's freedom for the rest of their life is not an appropriately tailored means of achieving public safety goals. And then finally, we had a procedural due process claim. And under that claim, we said people whose host sites are denied have no opportunity to contest that denial, even if it's wrongful, even if the host site that they've proposed is compliant with all of these laws. If the IDOC rejects it, for whatever reason, because the parole agent made a mistake, because the parole agent couldn't immediately contact the host, people were given no opportunity to appeal. And so our claim was that that violated the procedural due process clause. We litigated the case for several years, and ultimately, in March of 2019, we were successful. Judge Virginia Kendall of the Northern District of Illinois granted summary judgment in our client's favor on the equal protection and Eighth Amendment claims. And with regard to our procedural due process claim about the denials of host sites and our client's inability to appeal those denials, she set that matter for trial. She found there were disputed facts that required us to go to trial on that. The basis for Judge Kendall's decision in our favor was essentially the disparate treatment of people based on their poverty. Essentially, she found that this amounts to a punishment for poverty. And here's what she wrote. The defendants have created separate consequences for indigent, homeless sex offenders and for non-indigent, non-homeless sex offenders. Only those who have no financial resources suffer a continued deprivation of liberty following the completion of their court-ordered term of incarceration for the original sex offense. The defendants are punishing the plaintiffs for their indigency and homelessness, matters totally beyond their control. To the Department of Corrections' credit, they did not appeal this decision. They essentially consented to trying to solve the problem. I think they've realized that this is a situation that is unjust and needs to be corrected. And so Judge Kendall has entered a permanent injunction. We spent a few months trying to negotiate a resolution. Ultimately, we weren't able to reach a final agreement. So Judge Kendall entered a permanent injunction in January of 2020 that has three basic components. The first is that the IDOC had to come up with a compliance plan by which it would release all the members of our class by no later than January 2021. Second, the IDOC has to periodically report to the court on what steps it's taken to meet that deadline, what progress it's making towards that deadline, and what's standing in the way of their releasing the rest of the class members. And then finally, the order provides that there is a possibility for monetary sanctions against the IDOC if the deadline isn't met. So fast forward 3 months from there, the IDOC put forward its compliance plan, and they made several reforms that are helpful and that are making it easier for people to find host sites. One is they've agreed to stop applying child-specific restrictions to people whose offenses involved an adult. So, for example, they are no longer prohibiting people with adult-only offenses from living within 500 feet of schools, parks, playgrounds. They're only applying those restrictions as required by Illinois law. They agreed to implement a process whereby people whose host sites are denied can appeal. Any host site denial is supposed to be put in writing, and anyone whose host site is denied has an opportunity to have that denial reviewed by someone who's above the parole agent and can overrule their decision if it's wrong or if the denial is unnecessary. IDOC agreed to enter into a contract with at least one transitional housing provider to provide transitional placements for people who can't afford their own housing. And IDOC decided to walk back some of their restrictions that were imposed solely as a matter of IDOC policy rather than as a matter of Illinois law. So, for example, the mere presence of Wi-Fi at a house won't lead to a host site denial. The presence of children's items won't lead to a host site denial. The presence of a pet on the premises won't lead to a host site denial. They also agreed to walk back their interpretation of this one registrant per address rule and stop applying it to trailer parks, apartment buildings that are next door to one another, and things of that nature. Mark and I continue to aggressively follow up on behalf of members of the Murphy class because many of them still remain in custody. And for the first 3 months that this injunction was in place, the Illinois Department of Corrections only succeeded in releasing 8 members of the class. And by the time we got to March, the class was actually larger than it was when summary judgment was entered. When Judge Kendall granted our summary judgment motion, there were 290 people who were in this situation. By March 2020, there were 321. Because as more people were finishing their sentences of incarceration, they were finding themselves in the exact same boat as folks who were already in that situation. So then the pandemic starts, and this really lit a fire under me to advocate more aggressively on behalf of our clients because people were stuck in prison and we had COVID starting to spread in IDOC facilities, people getting sick. And we knew for a fact that there were at least all the members of the Murphy class, so that was over 300 people, and then probably 1,000 more people who'd been convicted of sex offenses and had determinate sentences of MSR who were also stuck there wrongfully. People who had finished their terms of incarceration should be out, but they couldn't because they did not have an approved host site at which to live while on mandatory supervised release. So one day I got a call from the sister of a man named Marcus Barnes. And what she explained to me was that Mr. Barnes had completed his sentence of imprisonment. His family had been searching for a host site extensively for months. They had proposed 11 different host sites for Marcus, all of which had been rejected by the IDOC for various reasons. Marcus was in an IDOC prison where COVID had been introduced. People around him were catching COVID. And the sister called me because she had identified a transitional housing provider, one of the few in the state, that was willing to take Marcus, willing to take people with sex offense convictions. But the only thing standing in the way was this one registrant per address rule. The IDOC rejected this transitional housing provider because there was another person with a registration requirement already living there. So I will be candid that I did not have a good legal strategy at that very moment. All I knew for sure was that this situation was manifestly unjust and should not be happening. Marcus Barnes should be out. He should not be in an IDOC prison facing a risk of being infected with COVID when he had an otherwise safe and welcoming place to live in the community, where he could be doing his MSR time and getting on with his life. I also had a hunch that our judge might see it the same way. She might see this as an injustice and she might be willing to do something about it. Over the course of working on the Murphy case, Judge Kendall got to know these laws and the various ways they function and malfunction very intimately. We submitted very lengthy briefs explaining every aspect of the law. She'd had long conversations with the parties about what the possible solutions were. And one thing that I think everyone agreed on, the plaintiffs, the IDOC, and the court, was that this one registrant per address rule was one of the biggest sources of the problem. It was probably the worst cause of putting housing off limits that otherwise could be approved for people. And B, that there wasn't a very strong public safety rationale for this law at all. The IDOC had really never put forth any public safety justification for why only one registrant could live at a particular address. So we filed a second lawsuit, and this one is called Barnes versus Jeffries. And we aimed this lawsuit simply at this one aspect of the law, the one registrant per address rule. And we consolidated the case in front of Judge Kendall. As I've admitted, going in, I didn't have a great legal theory. My first salvo here was, this is deliberate indifference under the Eighth Amendment. People who could otherwise be out of prison are being exposed to an absolutely unreasonable risk of contracting COVID, which was spreading like wildfire among imprisoned populations. And later, we amended this complaint to essentially mirror the successful theories that we'd had in Murphy, which is that really this is doing the same thing that the broader scheme was doing in Murphy, criminalizing poverty and homelessness, putting all free or low-cost housing options off limits to people. And in the absence of a stronger public safety rationale for the law, this simply wasn't an appropriately tailored way to achieve public safety goals, keeping people in prison who otherwise could be out, but for this one person per address rule. And to our pleasant surprise, we quickly gained some traction with this theory. We immediately were able to obtain a preliminary injunction that allowed Mr. Barnes to be released to the halfway house that his sister had identified for him. We were able to certify the case as a class action. And we've continued to file additional motions for preliminary injunctive relief on behalf of other members of the class who have places to live that could be approved, but for this one person per address restriction. And this lawsuit and the preliminary injunctive relief that we've obtained for people has led to approximately 200 other members of the larger class finding places to live. We have filed a motion for summary judgment, asking the judge to enter a final order invalidating this law. And we obviously don't know exactly what's going to happen. I can't predict the future, but I'm optimistic. The judge has been willing to grant preliminary injunctive relief for people to go to a variety of different types of housing settings. At no time during that litigation has IDOC really articulated any public safety interest that is served by this one registrant per address rule. And so I am hopeful that we will get to final judgment in our favor on this claim. This has really changed the game for members of the Murphy class and for people who've been convicted of sex offenses more broadly. A lot of new housing options have been made available because of this Barnes case. One, charitably operated halfway houses who are willing to take someone with a sex offense conviction can now do so because there's not this restriction that says only one person per address. So some of our clients have been able to go to a place called Wayside Cross Ministries, which is a Bible-based halfway house that the registrant or the person being released on parole does not need to pay anything out of pocket for 7 months. So that's been a great option for some people. Other of our clients were able to get out because they were able to defray the expense of housing by sharing it with someone else. So for example, one of our clients had a military pension because he served in the United States Armed Forces and was retired from the military. So he was able to buy a house, and he actually has brought 2 other parolees with him to his home, something that would have been impossible under this one person per address restriction. Transitional housing providers that were previously off limits are now an option. And then people who wanted to live with their own families have now been able to do so. In the past, if the family lived in a building that had another registrant in it, or if another member of the family was a registrant, those placements with families would have been off limits. I think the best result of the Barnes litigation so far has been that it's caused the IDOC to be able to greatly expand its transitional program. So under the Murphy injunction, one of the things the IDOC agreed to do was start a transitional housing program for people with 3 to life sentences. But that program started very small. As I said earlier, in the first 3 months, they were only successful in releasing 8 people. And that's because when they rented a place, they could only put 1 person at 1 address. As a result of the Barnes case and the preliminary injunctive relief we've received there, the IDOC has greatly expanded its transitional program. So, for example, they're working with a provider in the suburbs called New Day Apartments. And New Day specializes in renting to people who are on the registry, has a deep understanding of all the laws, and they're a good provider for the IDOC to work with. But at the 4 houses that IDOC contracted to rent out from New Day Apartments, they were only able to put 1 person at each of those addresses, even though they were 3-bedroom apartments that easily could have accommodated at least 1 or 2 more parolees at each of those locations. So as a result of the Barnes case, that changed. And so their transitional program through New Day Apartments greatly expanded, and they started a second contract with another provider, and they've been able to move 40 or 50 more parolees into that. Okay, so I'm optimistic that we are seeing some real progress on the Murphy case and getting the members of the class out of IDOC. In the room of silence that I don't see. And maybe one of the things that makes me happiest about all of this is that Paul Murphy, the person who started it all, was finally released in September 2020. And there's a selfie that I made him take with me when we dropped him off at his new home, where he's now residing with 4 other parolees. So that's an update on our efforts on behalf of people imprisoned in IDOC who can't get out because they can't identify housing. So there's still a lot of work to do. There's still a lot of members in the class, still a lot of people who can't find a place to live, but I am heartened by the progress that we're seeing, and I'm optimistic for the first time since we've been working on this that we're going to solve the problem. And so that's my presentation about our litigation. I can answer questions if anyone has them. Yes. All right.
Adele, good afternoon. Can you hear me?
Yes.
Great. So one of the general questions is, we know what our arguments are, your argument is as an attorney, and what Mark would argue. What is the state going to argue? How are they going to come back after? And what are their pleadings? Why are they saying that the law should remain in place, and why should they not be changed?
So to IDOC's credit, after they lost their summary judgment in the Murphy case, they decided not to appeal. And I think that's a good thing. I think that Judge Kendall wrote her decision in such a way where she didn't single out a particular law, because I think it's much harder as a lawyer doing this type of work to knock out particular laws. Because for each individual law, the IDOC can come up with, or the state can come up with, some explanation of why it's important and why it serves an essential public safety interest. But what Judge Kendall ultimately said was, this whole system and the way the IDOC is applying the host site requirement to people who are in the system is unconstitutional. And so I think that's why we were able to succeed, was that we looked at it holistically rather than starting by going after just a single law or one or two laws that we identified. With regard to the one person per address restriction, it's been interesting to litigate that, because the IDOC has said very generally that this is a legislative judgment. It's something that the legislature decided was important for public safety. They haven't been more specific than that. And I'm not going to speculate about why that is. Maybe I will speculate a little in that my guess is that this law is making their lives hard too. I think that the IDOC knows they have to be able to release people eventually, and this law is one of the major things standing in the way. So that's where we're at.
And another question we got was about cost effectiveness. Is it more cost effective? I would think, as the person said, this is going to be outrageously expensive to continue to house someone in our prison system rather than letting them get out and hopefully become employed again and get back into society, rather than literally simply housing them. Because do you know what the average cost is per year per person?
At the time we filed our summary judgment motion, it was a little over $30,000 per year per person in the IDOC. And their estimate of how much it cost to supervise someone in the community was $2,000 a year. So it was, of course, quickly adds up to millions to keep people in prison indefinitely rather than have them on community supervision. And even with IDOC paying out of pocket to house people for 3 to 4 months through this transitional program, the savings are still massive, because we've had good success with this program so far. People are released to these transitional placements who had no options because they didn't have money, and they get jobs and they move out and they find their own place and they can succeed on parole and get through and out of the system.
Sure. You had mentioned earlier, and someone was concerned about the lack of halfway houses in the state. It was actually kind of a two-part. If someone is a federal And there is one federal prison, I believe, Marion, in downstate Illinois. Does that apply both to federal and state? And can you, as an attorney or any attorney, litigate that and force a halfway house if they meet all the criteria to take a sex offender?
Can we force the halfway house?
Well, I guess force is probably too strong of a word to use, but I assume, and I think the person is assuming, that the halfway houses will not take us because they're going to say fear or it doesn't meet the standards or whatever. Can that cycle be broken with the halfway houses?
I think some halfway houses are willing, and they just haven't because the legal requirements made it impossible, particularly this one registrant per address rule. Other halfway houses have taken the viewpoint that it's too risky and too expensive, and they're not willing to take someone with a sex offense conviction. We'll see what happens. I guess I would say contact me if there is a particular place you have in mind, because I love the opportunity to reach out to these halfway house providers and talk to them about their willingness to consider people with sex offense convictions, because I think that's something we can certainly try to help facilitate through the courts if the provider is willing.
Okay. And one other question, and again, you touched on it both now and I think during the when you were speaking, the one sex offender per unit. Here in Chicago, obviously, we have multiple units in multiple low-rise, high-rise buildings all over the city, all sections of the city. Is that going to change? And does it matter if it's both are going to be still on probation, or one is completely off probation and one is just coming in, and if that makes any sense?
Sure. So the Illinois statute, this one person per address statute, is part of the parole statute. So it's not like the 500-foot rules are part of the criminal code. So that's a violation of law to live within 500 feet of a prohibited location. The one person per address statute is just a parole rule, which is different. It's not an independent offense to live at the same address as someone. So there is more room for us to try to get rid of that law. Right now, the way it applies is a person on parole can't live at the same address as another registrant, whether that person is on parole or not. So the parolee is really the only person who is in the situation of their housing potentially becoming non-compliant because of the presence of another registrant. But like I said, I can't read the future, but I'm fairly optimistic that that law is going to be found unconstitutional. There really hasn't been a good public safety justification put forth for it. The evidence is overwhelming that this is a huge cause of the constitutional violations that are ongoing for members of the Murphy and Barnes classes. And so I'm optimistic that the federal court is going to see that and is going to strike down the law. I think the preliminary injunctive relief that's been granted for almost 200 people is a good sign that this law is not really essential to public safety and is potentially subject to a strong constitutional challenge.
Okay. And I apologize, but someone did want me to ask, this is kind of out of what you were talking about, but they're concerned about the parks and park recreation and being forbidden. Anything down the pike coming where that will change? Is anyone challenging that? Anything that you know about that one?
I'm a little pessimistic about the viability of challenges to the park restriction right now, for a couple of reasons. One is that, as anybody in Illinois and anybody who follows Illinois Voices probably knows, there was a very sympathetic case that got up to the Illinois Supreme Court on behalf of someone who was prosecuted simply for walking his dog near Park District property. So there was no allegation that the person was doing anything untoward or illegal or trying to do something illegal. There was no evidence even that there were children in the area. And ultimately, the Illinois Supreme Court upheld the constitutionality of the law. And it is a harsh law. And if I was in charge, it obviously wouldn't exist. I'm a little pessimistic about the viability of a constitutional challenge to that law right now, to be completely frank.
What happened? So Illinois, the Supreme Court turned it down. Can you or Mark or any other attorney then go over the Illinois court?
So there's two potential routes for these types of challenges, right? One is through the state courts, the other is through the federal courts. And, I'm not giving away state secret when I say that the Seventh Circuit Court of Appeals that covers Illinois, Indiana, and Wisconsin has become one of the most conservative appeals courts in the country. It's populated mostly with judges that have a more conservative view of what the Constitution covers and doesn't cover. And so the Seventh Circuit does not view these rights expansively. We litigated a case concerning the residency restrictions in Illinois, and in particular, the lack of grandfathering under Illinois law. So somebody who is off any kind of supervision, maybe even off registration, is living in a lawful address, their address can become unlawful if someone decides to open a daycare near them, even though the registrant or the person subject to this law has done nothing wrong. And we litigated a host of constitutional challenges to that law on behalf of two plaintiffs whose situations were appallingly unjust. These were people who had gone on to have productive, happy, healthy lives in the community after committing offenses when they were quite young. And they had longstanding homes with their families, were doing so well, and then were both given notices they had to move out of their homes within 30 days or be prosecuted for a felony because someone within 500 feet of them opened a daycare. And the long story short is the federal district court made short work of that case, dismissed it on a motion to dismiss, finding there was just no viable challenge under the Constitution to that law. That judge who issued that decision is now on the Seventh Circuit, thanks to Mr. Trump. And the Seventh Circuit affirmed her decision, in a quite strong decision, finding that it was just a civil regulation, not a punishment, no procedural due process right before this law was applied to you. It was heartbreaking. It was all wrong, and it haunts me to this day. And all this is a long way of saying I would not feel confident bringing a federal challenge to the parks restriction at this time, given the makeup of the Seventh Circuit and the kind of narrow way they see constitutional protections.
Our latest U.S. Supreme Court justice just came out of the Seventh Circuit. Am I correct?
That's right.
Right?
Yes.
Okay, so it gives us a good indication of what's going on. So we have a few more minutes left. Are there any last thoughts, comments that you would like to raise, or are there any questions that were not asked that you think, boy, I've been waiting for this question and no one's asked it, that you'd like to tell us about or talk about?
Sure. I can talk briefly about some of the next steps as we see them after this litigation on behalf of people who can't get out of IDOC onto MSR. This has really opened our eyes, Mark and I both, to the realities of being on MSR in Illinois and some of the very broad discretion that parole agents have and some of the rules that are applied to people who have sex offense convictions while they're on MSR. So we have two pending lawsuits about aspects of supervision, including a restriction on people having contact with their own minor children while they're on MSR, and a restriction on internet use while people are on MSR. And both of those cases are currently going. And so I think that's the next frontier of things we're working on, is trying to push back against some of the worst abuses of the parole system as we see it. So that's something we're interested in. And I'm hopeful we can shed some light on this very opaque system. Not a lot of people pay attention to what happens to people on supervision, and there's insufficient attention paid to how abusive that system can be. And so that's been eye-opening for us, and that's something we're very excited about working on. And I'm hopeful that we can have some successes there to make that system a little bit more just.
Have any of the other states been, or has anyone else in any of the other states been successful in any of these areas that you've talked about? And does that set precedents?
There's been a little bit of litigation related to parole issues in various places around the country. So I know Paul talked earlier, there was a case that his counterpart Miriam had done about child restrictions on contact with folks' own children while they were on supervision. That was a good precedent for us to use in our case. So we've raised some of the issues there. Internet restrictions is kind of a hot area of litigation because there was the Supreme Court Packingham decision several years ago that found it was unconstitutional to restrict access to social media simply because someone is on the registry. And so we're trying to build on that success in that case and show why the same rule should really apply to internet bans for people who are on supervision.
Okay. What else do you need to tell us? And while you're thinking, is there anything that I mean, you all are on the front line in the courts fighting for us, but is there anything that we can do as a group to assist either both of you in specifically at a micro level or on a macro level, reaching out to our representatives, anything politically or anything at all that you would recommend if someone wants to be more active in how to bring about and change these draconian laws? What would you recommend?
I think there's a lot of great ways to get involved. I mean, one is being part of a group like this, where you're kept up to date on not just the litigation, but also the efforts to change some of the legislation. In Illinois, we have a great group that you're part of, David, called Illinois Voices for Reform, which is affiliated with NARSOL. And Lori Jo Reynolds, who's on the board of Voices, is actually working very hard on a piece of legislation that would try to correct some of these abusive parts of Illinois law. So I really recommend staying involved with NARSOL, getting involved with your local affiliate in your state, and looking out for those opportunities where you can talk to your legislators and tell your story and support those efforts.
Have you been able to knock on any of the legislators' doors? Do they listen to you at all, or is that not really where you and Mark go?
You know, there are different schools of thought about this. I personally don't think that anything that Mark and I would have to say would be that persuasive to legislators, simply because we're situated adversarially to them in the courts. And but I do think these efforts can work hand in hand. What I hope is that the evidence that we brought to light in the Murphy case and are continuing to bring to light in the Barnes case can help make the case to legislators that they need to take another look at these laws, because it's costing the state a ton of money. The laws are malfunctioning horribly. It's a situation that is untenable financially and morally. And so what I'm hoping is that some of the facts that we developed by litigating these cases can work hand in hand with those efforts to reform the laws through the legislature.
Great. Adele, thank you so much. On behalf of myself and all of us in Illinois, we thank you. And of course, we thank Mark. Appreciate your spending the time with us today, this afternoon. Always wonderful hearing you and what you have to say, and I thank you so much. Don, I'm going to throw it back to you now.